Is an unjust law not a law? The point of a law is to be obeyed. Laws are obeyed by the bad man, as Oliver Wendell Holmes famously said, because the bad man knows there's a likelihood of punishment if the law is disobeyed. If the law is not obeyed, it has to be enforced. However, the good man obeys the law because he believes the law ought to be obeyed. The reason for obeying laws is that laws are not just rules, they're a particular kind of rules, rules made for the good of their subjects. For this reason, Nigel Simmons has contended, analysis that reduces law directly to the facts of power comes at too high a price, being unable to explain and accommodate the language of rights and obligations by which most, if not all, regimes articulate law's demands. The point he's making here is that whatever reason officials have for making certain rules, the justification for the rules they must present to their subjects is that the rules are just. Robert Alexie calls this the claim to moral correctness. Because laws must always claim to be just, the question then comes, what if that claim is totally false? Is an unjust law still a law? Thomas Aquinas discusses this question twice in the Summa Theologiae. In the first instance, in question 92 of the Prima Secundae, the answer he gives is that a tyrannical law is not a law, absolutely speaking, but rather a perversion of law. A proper law has three elements. It's made by a superior, it aims to be obeyed by its subjects, and it's made for the good of the subjects. Now, assuming the lawmaker is not a usurper, a tyrannical law ticks the first two boxes, but it does not tick the third box. It's a defective law because it's not made for the good of the subjects. The point of the law has been perverted. Aquinas returns to the issue, question 96 of the Summa Theologiae. On this occasion, he wants to explore how subjects should react to unjust laws. He says, I answer that laws framed by man are either just or unjust. If they be just, they have the power of binding in conscience. Now, laws are said to be just both from the end, when, to wit, they're ordained to the common good, and from their author, that is to say, when the law that is made does not exceed the power of the lawgiver, and from their form, when, to wit, burdens are laid on subjects according to an equality of proportion and with a view to the common good. Such laws as these, which impose proportionate burdens, are just and binding in conscience and are legal laws, leges legales. On the other hand, laws may be unjust in two ways. First, by being contrary to the human good, through being opposed to the things mentioned above, either in respect of the end, as when an authority imposes on his subjects burdensome laws, conducive not to the common good, but rather to his own cupidity or vainglory, or in respect of the author, as when a man makes a law that goes beyond the power committed to him, or in respect of the form, as when burdens are imposed unequally on the community, although with a view to the common good. These are acts of violence rather than laws, because, as Augustine says, a law that is not just just seems to be no law at all. Wherefore, such laws do not bind in conscience, except perhaps in order to avoid scandal or disturbance. Secondly, laws may be unjust through being opposed to the divine good. Such are the laws of tyrants inducing to idolatry, or to anything else contrary to the divine law. Laws of this kind must nowise be observed, because as stated in Acts chapter 5, verse 29, we ought to obey God rather than man. Now, Aquinas' discussion here takes place as an answer to the question whether human law binds a man in conscience. Laws in the focal sense, leges legales, do so successfully because they're able to make out their claim to moral correctness. They aim at the common good. They're made within the boundaries of a lawmaker's jurisdiction and authority, and they do not impose unreasonable burden on any particular group or individuals in society. Now, a law that's made beyond the scope of a lawmaker's authority would be struck down today as ultra vires in systems that allow judicial review. A law that imposes unreasonable burdens on any particular group or individuals in society could be struck down in systems that allow for substantive judicial review, or where discrimination or other human rights norms can override laws. But what about a law that is not aimed at the common good? Is that law invalid? Or is it simply that Aquinas says that subjects are free in conscience to disobey the law unless there are prudential reasons, avoiding scandal or social disturbance, for complying with it nonetheless? I don't think Aquinas gives a clear answer to that question, because he wasn't writing a manual on constitutional law for judges. He was writing a handbook to guide monks and other citizens faced with the problem of whether or not to comply with unjust laws. The difficulty with a position in which individual subjects only obey laws if they think they are just is that the notion of authority simply evaporates. Many Christian thinkers, from Augustine to Philip Melanchthon, have been attracted by the analogy between parenting and government. Parents have the right to tell their children what to do because parents are in a better position than children to discern what are the better and worse courses of action. So too, governments ought to be in a better position than individual citizens to decide what rules are likely to make a community more peaceful and more just. Even if subjects have the right to decide for themselves whether or not to obey particular laws, they ought to give their rulers the benefit of the doubt, a margin of appreciation, whether subjects will go along with the rules, even if they think that different ones should be in place instead. That is especially true in societies which are democracies, where there are standing mechanisms by which rulers offering different solutions to the dilemmas of government can be appointed. After the English Civil War in the 17th century, the philosopher Thomas Hobbes diagnosed its cause as an argument over authority. Civil peace depends, thought Hobbes, on having a single point of authority in a society, a sovereign whose rules were always obeyed. Hobbes's ideas were controversial, and the dominant tradition in the United Kingdom and in what became the United States followed John Locke instead. Locke argued that the authority of rulers depended on their respect for natural rights. But in the early 19th century, the utilitarian philosopher Jeremy Bentham declared the idea of rights to be nonsense, and the idea of natural rights to be nonsense on stilts. Combined with utilitarianism, legal positivism came to dominate the thought of lawyers. Laws were to be obeyed if they were valid. Laws were valid if their pedigree could be traced back to a sovereign. Thomas Hobbes' ideas were suddenly in fashion. This legal positivist view means that lawyers and officials dealing with the law stopped asking themselves whether the laws they were following and implementing were just. Orders were to be obeyed. This was particularly true in Germany, where the military discipline of the Prussian army formed a psychological model for the running of an orderly society. It meant that when Hitler became the sovereign, German lawyers, judges, and officials lacked the intellectual resources to resist going along with his murderous, genocidal, and crazy demands. These included following secret enactments, decrees which were never made public, but which authorized wholesale killings in the concentration camps. Gustav Radbruch had been Minister of Justice in the Weimar Republic in 1923. After the Second World War, working as a legal scholar by this time, he condemned legal positivism as a position that rendered the German legal profession defenseless against statutes that are arbitrary and criminal. Radbruch argued that the law ought to be understood in the way Aquinas had understood it. He said, "One cannot define law, also positive law, in any other way than as an order or statute that is by its very sense determined to serve justice. Laws are not simply any type of rules. They are specifically rules designed to serve justice." For Radbruch, this meant that a law which was completely unjust not only lacked the moral authority to bind the conscience of its subjects, such a law was also invalid. It ought not to be recognized as a law at all. Radbruch recognized this could only apply in extreme cases. In a 1946 article, he set out what has become known as Rad Brooks Formula. The positive law, secured by legislation and power, takes precedence even when its content is unjust and fails to benefit the people. unless the conflict between statute and justice reaches such an intolerable degree that the statute as flawed law must yield to justice. Good law, therefore, is designed to promote justice. Bad law fails to promote justice, but does not fall so far short of its aim as to cease to be valid law. Extremely unjust law is not valid. In Rad Brooks' own words, moral defects undermine legal validity if and only if the threshold of extreme injustice is transgressed. A particular example of this is where there's not even an attempt at justice, where equality, the core of justice, is deliberately betrayed in the issuance of positive law. Then the statute is not merely flawed law, it lacks completely the very nature of law. Now, some lateral law thinkers, such as John Finnis, argue that the question of whether a law ought to be obeyed and the question of whether the law ought to be enforced by authorities in the event of disobedience are two entirely separate questions. A thoroughly bad law fails to create an obligation to obey in a moral sense, but may still give rise to legal obligation in a legal sense. For Rad Brooks, although there's a distinction to be drawn, in extreme cases, a bad law ought to be regarded both by the subjects and by the authorities tasked with enforcing it as not a law at all. So to conclude, what should subjects do when confronted with unjust laws? Aquinas' answer is that they're free to disobey unjust laws unless there are prudential reasons for continuing to obey them. What should officials do when confronted with unjust laws? Rad Brooks' answer is that although unjust laws may still have to be applied, extremely unjust laws should be rejected, even by officials. They should regard them as not valid laws.